The political crisis in Rivers State has escalated as the State House of Assembly initiated impeachment proceedings against Governor Siminalayi Fubara and his deputy Ngozi Odu. The Assembly had on Monday filed a notice of impeachment accusing the governor of gross misconduct, particularly in the management of public funds, in violation of the Nigerian Constitution. The notice, signed by 26 members, was dated Friday, March 14, 2025. The letter, titled, quote, Notice of Allegations of Gross Misconduct, end quote, and addressed to the Speaker, Martin Amewule, outlined the governor's alleged violations and referenced a Supreme Court ruling which condemned Fubara's actions, stating that political disagreements do not justify contempt for the law. The Assembly also pointed out that Fubara had failed to present the 2025 appropriation bill to the House, despite previous instructions. Governor Fubara had planned to present the budget on March 12, 2025, but was denied entry to the Assembly complex. He later blamed the lawmakers for frustrating his compliance with the Supreme Court order to represent the budget. The lawmakers, led by Speaker Amewule, accused the governor of undermining the implementation of the Supreme Court's decision, specifically the directive to resubmit the budget. Now, what are the constitutional requirements to impeach a Nigerian governor as Rivers State House of Assembly initiates moves to sack Governor Fubara? Lawyer and public affairs analyst Maxwell Opara joins us now to provide legal perspectives to this issue and more. Good afternoon and thank you for joining us.
Thank you, Cynthia. Thank you, Omobolanle. It's my pleasure to be here once again.
Now, interesting times in Rivers State, or maybe not so interesting times, especially seeing that this face-off between the governor and the lawmakers seems to have reached its climax with this notice that has been served the governor and his deputy on, impeachment proceedings. What are the requirements, especially looking at coming from your perspective as a legal luminary? What are the requirements to impeach a governor? And all of the allegations that have been leveled against Fubara and his deputy, are they enough to meet up with those requirements for, impeaching a governor?
Well, I want to start by saying that the Constitution said what the members of the House consider misconduct. Now, having considered the actions of the governor that it amounts to misconduct, now they have commenced exercising their right under Section 188 of the Constitution. I did not provide the requirements. The Constitution provides the steps to take. Now, the one-third majority of the House has signed the petition, a written allegation to the Speaker. The Speaker has forwarded it to the governor. It is now left for the governor to do what? To respond. When the governor now responds, the motion will be taken. After considering the motion, if they feel that, yes, the actions of the governor actually amounted to misconduct, they will send it to the CJ for the CJ to set up a 7-man panel to look at it. If the 7-man panel came up with their report and they said that the governor and the deputy governor, their actions amount to misconduct, then they will take a motion and the governor will be removed, not impeached. The Constitution said removed. Now, but if the 7-man panel said that the actions of the governor did not amount to misconduct, that the governor never committed any offense, that settles it. And the Constitution, the same Section 188 sub 10, said that no judicial proceedings will be taken against such a determination. But one of the exceptions there is that if you are challenging the processes, more especially the governor cannot stop the House from exercising their right. But if along the line, under Section 188, Step 1, Step 2, Step 3, and they did not follow the due process in impeaching the governor, the governor and the deputy governor can challenge that process in the court of law. So that is the position. That's the procedure as enshrined, as established in Section 188 of the Constitution.
All right, Mr. Opara, thank you for outlining that. But how do you assess the judiciary's independence in adjudicating this politically charged matter?
Well, as a lawyer, whatever the court say that is the law remains the law. So, and you can only express your view about the judgment of the court, just like the judgment given by the Supreme Court in Rivers State and some other issues. You may have your opinion, expressing your opinion, criticize the judgment. It is your right to criticize the judgment, but that will not change that judgment. That judgment will stand. Then on whether the judiciary will do justice to it, that's a different ballgame altogether. I'm here to talk about the law. So whether the judiciary will take, but the position there is that where this particular, I feel that this particular impeachment will not have its way. From my own observation, it's like the judge, the chief judge is with the governor. And he has a very fundamental role, very important role, very crucial role to play. Because if the 7-man panel came up with their own report, whatever position, whatever processes the members of the House took will be a nullity. That particular report by the 7-man panel settles it. So that is the position.
You know, one of the allegations they leveled against Mr. Fubara is also the fact that he did not obey the Supreme Court order. That is to present, the budget to the State House of Assembly. But there were also controversies about how he wrote a letter to the members of the Assembly and how he went to the, the building or the State Assembly building, and he was not granted access. Would that constitute flouting or contempt of law, especially seeing that he made attempt to present the budget?
I love that. You call it allegation. They alleged. They have not proved it. They alleged. It remains allegation. Now, we have seen where Fubara drove to National Assembly quarters to go and present the budget, how they blocked him, refused him access into the premises. We have seen the letters written where the House said the letter was sent to them through social media, that the Secretary of the State Government was the person that signed the letter and what have you. And I thought that the legal team of Opara and the Attorney General and the legal advisors should have done more. What am I saying? They should have approached the Supreme Court. Remember that once the Supreme Court gave a judgment, that it remains final. Now, they should have approached the Supreme Court with affidavits of compliance. Then, that is to say, to force judiciary, to force Supreme Court to give further orders. What do I mean? Just like in where a court bailiff went to serve court process. You are expected to serve affidavits of compliance, whether you served or not served. Then, if you find out affidavit of compliance or non-compliance, together with a motion, asking Supreme Court to direct you. You ask me to do this, I want to do this, they are frustrating it. You ask me to do this, I have done this, they are frustrating it. Please, what can I do in this instance? So these are the issue, at least to force Supreme Court to give further directives on what to do.
Mr. Maxwell Opara, thank you so much for doing justice to this subject matter in such a short space of time. We appreciate your insight here on Newsday.